Okay, I think we'll make a start. So good morning or afternoon or evening, wherever you are. Welcome to the latest in our series of FOSI Briefs the Hill. My name is Stephen Balcom, and I'm the founder and CEO of the Family Online Safety Institute. And our mission is to make the online world safer for kids and their families. And we do that by working in what we call the 3 Ps of policy, practices, and parenting. That is enlightened public policy, robust industry best practices, and good digital parenting, empowering parents to confidently navigate the web with their kids. I'd say that one of our most important roles as an organization is to convene the best thinkers and practitioners in the field of online safety, and today is no different. Our gathering will focus on the role public policy is increasingly playing in the work and practice of online safety. The US Congress has seen a slew of legislation focused on regulating popular tech platforms. A number of bills have been introduced regarding antitrust, data privacy, content moderation, and most importantly for this discussion, online safety. And despite all of this activity, Congress has yet to pass a single bill. In contrast, Australia has passed an Online Safety Act and empowered its eSafety Commissioner with real authority. The UK has enacted and begun to enforce its age-appropriate design code and has introduced the Online Safety Bill, arguably the most comprehensive and impactful bill of its kind anywhere in the world. And the EU, which passed its comprehensive data privacy law in 2016, is moving forward with the Digital Markets Act and the Digital Services Act. So, in order and to help us to navigate these waters, I'm going to hand things over to my colleague, Andrew Zach, and to a wonderful panel of experts who can take us through this complicated series of events. So Andrew, over to you.
Thank you so much, Stephen, for that great framing and setup for our discussion today. As Stephen mentioned, so I'm Andrew Zach, FOSI's policy manager, and I'm thrilled to welcome our speakers today, true experts from around the world for this global discussion of online safety policies. And I'll let each of them introduce themselves, starting with Asha.
Thank you so much, Andrew, and thank you to FOSI for the invitation to join you today. I'm really happy to be here. My name is Asha Allen. I am Advocacy Director for Europe, Online Expression and Civic Space for the Center for Democracy and Technology. You may be familiar with our colleagues in our DC headquarters, but I am here joining you from our Brussels office. Thanks so much.
Thank you for being here. And how about Charlotte?
Thank you, Andrew. My name's Charlotte Ainsley. I'm a freelance digital safeguarding consultant in the UK. Been working in this area for a long time, since 2000. Was previously at the National Crime Agency, CEOP, and the UK Council for Child Internet Safety, and have been working freelance with various charities, commercial organisations for the last 10 years. Good to be here. Thank you.
Thank you both. And moving across the ocean and the continent, how about Landon?
Thank you all for having me. It's so great to be here. I'm Landon Klein. I'm a senior consultant for the California State Assembly Committee on Privacy and Consumer Protection. Over the past couple of years, we've increasingly been dealing with issues in kind of the social media and protection of children online space as those issues start to kind of intersect more directly with broader consumer protection issues and privacy issues more generally.
Fantastic. Thank you again all for being here today. So let's start in Europe. Asha, you're our Brussels representative today. What's the latest in online safety in the EU? We saw a principal agreement at the end of April on the Digital Services Act. Could you start by giving us a brief overview of the DSA, what it is, what its goal is?
Absolutely. I'm going to try and do my best in the short amount of time that we've got to cover what I can. But I think what the best thing for me to do is to maybe cover the main aspects of the DSA, specifically for the provisions related to online safety. But to start with just a very quick overview of the DSA, it's hundreds of pages long, so there's no way I'm going to be able to capture everything. But it is one of two central legislative pieces as part of the EU's digital strategy, which covers its semester over the 5-year period from 2019 to 2024. And as mentioned before, this was introduced alongside its sister legislation, the Digital Markets Act. Now, in brief, the DSA is an update to the 2000 e-commerce, the year 2000 e-commerce directive, and it essentially sets the rules and obligations for online content governance in Europe. It takes a two-pronged approach. It's very much a legislation that outlines obligations for handling illegal content. So the knowledge-based intermediary liability regime, the notice and action mechanisms, all of this is included in the DSA. But there is also a whole extensive chapter dedicated to due diligence provisions. And this is aimed at provisions over legal content that can still negatively impact the digital ecosystem. So these include extensive transparency obligations for all platforms and additional measures for what are known as VLOPs, so very large online platforms. And these include transparency reporting, adaptation of content moderation practices, openness to third-party independent audits. The list is extensive. But before we jump into the details, I think it's super important to clarify that the text of the DSA is not finalized. So you mentioned that we have a provisional agreement, but the text is still being fine-tuned as we talk right now. EU policymaking is an incredibly long and complex process, I cannot overstate this, that involves 3 separate institutions with different roles as co-legislators and initiators who have individual processes that they have to undertake, as well as collective processes they have to go through before anything becomes law. But as you mentioned, we did reach that political agreement. So the kind of final version of the text, where details still need to be ironed out, were at least agreed. And right now we have lawyer linguists in the EU institutions who will review that text and ensure legal clarity, and analysts and advisors at the technical level who will conduct a kind of final review. But just to be very succinct, the final text will still need to be reviewed by the parliamentary committees, in which all 705 members of the parliament will have to vote off on it. The council will have to sign off on it. So we're not expecting the DSA to come into force until Q1 of 2024. But I don't know how much time I have left, but if I still have a few minutes, just to kind of cover precisely some of the provisions there that are related to online safety. So subjectively, the 2 most prominent provisions in this area are articles that we have on systemic risks and mitigation of those risks. And this is what truly sets the DSA apart, actually, in terms of how it will shape the ecosystem, and effective implementation of these provisions will radically change online content governance. So based on these provisions, very large online platforms will now be required to identify, analyze, and assess any systemic risk stemming from the design or function of their services. And these risk assessments will need to take into consideration their algorithmic systems, recommender systems, enforcement of terms of services, data collection, profiling. The list is very, very long. They will need to adopt measures which will be subjected to independent and European Commission review on how to mitigate those risks. And this doesn't apply to risks relating to illegal content, of terms of services, and specific risks that very large online platforms need to take into consideration. But it is any risk to the rights under the EU Charter of Fundamental Rights, and all of these must be mitigated. But the risks, the specific ones, include risks to, say, civic discourse, electoral processes, and public security. And there are targeted measures for the protection of minors as well, which I will just quickly elaborate. But these assessments will need to be shared with the national level enforcement bodies, and the European Commission will also be the primary regulator for very large online platforms. and it needs to be opened up to vetted researchers, which will include civil society organizations, to be able to access the data and help with the implementation of these specific measures. So very quickly, there are targeted measures on the protection of minors. However, we have a new article that was introduced during the trilogues. I'm using an EU term here. It's the interinstitutional negotiations that happen once all the institutions have had a chance to amend the text, and then they come together to figure out what the final text will be. And this is specifically the online protection of minors. And included in this includes provisions that says any online platform that's accessible to minors, so potentially all platforms, need to put in place appropriate and proportionate measures to ensure a high level of privacy and safety and security for minors. It also introduces a blanket ban of targeted advertising based on profiling towards minors. So targeted advertising towards minors is now banned. But on this latter point, it is also very specific that platforms are not allowed to process any additional data in order to conduct age verification in order to comply with this particular regulation. So it's going to be very interesting to see how this is going to be enforced. So these are just two aspects that I delved into today, but I mean, there's a lot that the DSA tried to capture. I think how these provisions on online safety in the DSA will be implemented is yet to be seen. What's important is the discussion around these provisions raise really important reflections for the need for strong privacy protection and safety measures for all users. So whether the DSA achieves this goal very much depends on effective enforcement. And we at CDC will continue our prolonged advocacy strategy in order to bring this to life, as we simply just don't want another GDPR situation on our hands where we have a great legislation that unfortunately cannot be enforced as effectively as we would like it to. But there's a lot more information I can go into. I wanted to save the time for our other panelists to be able to share, and I hope that was okay for now. Thank you.
Thank you, Asha. Yes, that is, as you said, a massive piece of legislation and so many different pieces that I want to dig into, and hopefully will set us up for the other panelists as well. Especially, I heard you talking about harmful content, risk-based approach, transparency requirements, high levels of privacy and safety by design for minors. I think that immediately transitions to the UK and the work we're seeing with the age-appropriate design code, as well as the online safety bill. So maybe I can queue up Charlotte to discuss either of those actions in the UK or expand on anything we've already discussed, which I'll with more specific questions as we go.
Thank you. Yeah, thank you, Andrew. And there are lots of similarities between the DSA and certainly the online safety bill and the age appropriate design code. I'll talk a little bit about the age appropriate design code first, because that is already enshrined in law. It came into force last September. Web services were given a kind of year lead-in time. And we have a new information commissioner who at the start of the year said that they were going to start looking quite hard at some of the websites and services that provided services to children. There are 15 standards contained within the Age Appropriate Design Code. It's sometimes known as the Children's Code. I guess the most important thing to say about the code is that it's child-centric. So it's very much ingrained in the rights and privacy of children in the online space. It's very much ingrained in privacy, but it has quite a big impact in terms of online safety. And if you look at some of the 15 standards, particularly those around the first one, which is companies always acting in the best interest of the child, that's the primary concern. And what it ultimately says is that where you have a website or service, if you can't verify the ages of the children on that service, then you must treat them all as children, which effectively means you have to apply all of the 15 standards that are in the code. It's interesting that some of the code doesn't apply to every single website and services. And one of the debates that we've had here in the UK is around the ed tech industry and how much data sits within these environments, virtual learning environments, learning platforms that children access every day. And certainly during COVID, they've been accessing learning platforms, but even when they're in school, they're accessing platforms to do their maths, to do their geography, whatever subject it is. So we're very much having that debate at the moment in terms of the scope of the age-appropriate design code. The other big thing that you've alluded to and that you've mentioned is obviously the online safety bill, which is incredibly comprehensive. I think it's currently around 283 pages long. At committee stage at the moment. So at the end of June, it's being scrutinised at the moment. At the end of June, it will go into its next phase. It's probably not going to be enshrined in law until next year or even the year after. It's very similar to the DSA in the fact that it very much takes a kind of risk assessment and duty of care approach. But what it does do is it really tells organisations, especially those tier 2 organisations that enable children and adults to share content, to share imagery, that they need to mitigate risk and they need to demonstrate how they are mitigating risks. There is already codes of practice associated with child sexual abuse imagery and also radicalisation, terrorism-related content. So there are some early codes of practice that have been developed by Ofcom and industry, and people are expected to already be adopting those where they can. So lots of things happening. It's being debated really, really widely. Over the last few weeks, there have been some new areas introduced into the bill, namely around things like online fraud. I would suspect that over the next month, 6 weeks until the end of June, there will be additional things introduced as well. Again, in the UK, there's lots of debates around things like encryption and sharing imagery through encrypted services, and lots of the child safety organisations challenging about, where that sits in the bill and how it should be integrated in there. It's fair to say that we are slightly further down the line than Europe. Australia is obviously already in a space where they have their Online Safety Act, but we are getting further down the road, and there's lots of discussion, debate, lots of engagement from organisations with Ofcom, who is the regulator in this space.
Thank you. Again, a lot of action happening in the UK. And it does seem that, not to make it about page length, but it does seem that the EU and UK are really trying to be as comprehensive and also as detail oriented as possible to make legislation this long. There's much I want to follow up on, and I will. I just first want to turn it over to Landon, maybe focusing on the transition between the age-appropriate design code as it exists in the UK and what California is working on, their own version. And I will acknowledge it's a much shorter bill. It's a little bit more direct. So I'll turn it over to Landon.
Thank you, Andrew. And thank you, Charlotte, for beautifully setting up, I think, what's going on over here. So California is in kind of an interesting position relative to the EU and the UK, because we're dealing with some of the broader constraints of federalism. We're sort of constrained by what's happening at the federal level, but still kind of tend to see a little bit more rapid movement over here in California. So California has been a leader across the United States in passing legislation to deal with issues online, including data privacy and online safety. I do want to disclaim before I get into kind of the nitty-gritty of what's going on that the bill, the Age Appropriate Design Code Act, may end up coming back before the committee that I work for. So anything that I'm saying here is not on behalf of the committee, it's on behalf of me. Now that that's gotten out of the way, so the Age Appropriate Design Code in California is an interesting effort to try to kind of translate some of what's going on in the UK Age Appropriate Design Code into the United States, and specifically into California. It differs in a number of ways, partly because of the differences in the structures of legislation in the UK and in the United States. For one, there appears to be kind of less of a principles-based approach in California. In the US in general, and in California specifically, we tend to be a little bit less comfortable with kind of guiding principles as the actual substantive provisions of legislation. So a big part of kind of translating the UK Age Appropriate Design Code into the United States has been kind of narrowing some of these broader principles into specific provisions. I think what the age-appropriate design code in the United States, in California, is likely to do that dramatically changes the existing paradigm is California laws and United States laws dealing with children's privacy largely operate on a standard of actual knowledge. So it requires that the website knows the age of the individuals it's targeting or is directing the website to children. This allows a lot of these technology companies to turn a blind eye to age verification. And essentially they kind of assume that if they don't know the ages of individuals, they can presume that the individuals are adults. What the age appropriate design code would do is it would require a higher level of default privacy and security and a presumption that the individuals who are using the website are children, unless they can be verified to an extent to demonstrate otherwise. So there are federal laws protecting children online that operate on an actual knowledge standard. There's several in California as well. This would be the first to create this concept of likely to be accessed by children, which is broader and provides these provisions by default. Largely what the age appropriate design code in the United States would do is it would take this kind of best interest concept as sort of a guiding principle of the legislation, and then would establish a number of default privacy protections that go beyond the default privacy protections available to adults. So things like requiring notification if an individual's precise geolocation is going to be tracked, by default prohibiting the collection, sale, and sharing of personal information of children, prohibiting profiling. Again, these are all sort of concepts that have been previously introduced in California legislation, but have not been established by default and have not, in many cases, gone the distance. Some of the challenges that we're facing in the United States in California that aren't being faced in the UK are largely based on the fact that there's a much broader kind of privacy and online security infrastructure that exists in the UK and in Europe, in part as a consequence of the establishment of the GDPR. We're still sort of finding our footing in terms of establishing the actual institutions that can kind of govern this. So for example, where enforcement comes from is still an open question in California. We've recently established a privacy protection agency, but it has kind of a specific mandate. So figuring out where Attorney General enforcement versus this body's enforcement come about is one of the open questions. The other is, of course, because federal law explicitly preempts California's ability to do certain things in the content moderation space as a consequence of Communications Decency Act liability protections. We have to be very careful about how we construct the laws here to make sure that we're not overstepping our authority in the state of California to act. So I'll leave it there and we can kind of jump off of that for the discussion.
Fantastic. Yeah, there's so much, as you all expertly explained, there's so much distinction and difference here. There's a lot of overlap, but given the different rights-based or privacy-based laws that exist in the different jurisdictions, it is dramatically different when you're trying to implement them in a state versus at the national level versus the international level. We've had some great questions come in already from the audience. So if you'd like your question answered, please submit it to the Q&A. One thing to start with that is very significant, you mentioned, we talked about a little bit of age assurance, age verification, and knowing if your user is a child. So we'll get into that in a moment. But a question is, what is the definition of a minor that came in? And I know that varies from place to place. In the US, at least current law under COPPA, it's under 13. And that's drastically different than what has been passed in Europe and what people are considering. So I don't know if each of you just would like to touch on that, what the DSA considers, the definition of a minor.
I think if you guys don't mind, I'll start on that because I think it's the most complicated probably here. So as Andrew pointed out, under federal law, the definition of a minor is 13. California has passed the California Consumer Privacy Act, which is the guiding general privacy protection for the state of California. In this bill, it kind of has two different categories of minors. So there's a category of minors under the age of 13 that require the most protections. Basically, they're not in a position to be able to consent themselves to permitting the sale of their personal information. There's also a separate category of individuals under the age of 16. These individuals can make their own decisions with respect to whether to sell their personal information, but they still have to opt into that process. Anything over the age of 16, and it's an opt-out system. So we've sort of, and depending on the various laws across California, some of them kind of kick in at the age of 16, some of them kick in at the age of 13. It's not particularly consistent. What I will say is that the Age Appropriate Design Code Act that is moving through the legislature right now establishes a minor as anyone under the age of 18. So this is actually a bit novel with respect to online safety and privacy legislation, which, as I mentioned, at the oldest has kicked in at age 16 previously.
So maybe I could come in very briefly on the DSA. So the DSA itself does not provide a definition on the term minor. In kind of EU law and kind of historical reference, there has always been a reference to the UN Convention on the Rights of the Child, because all EU member states are party to that convention. So there isn't kind of an agreement in the DSA. I think there is assumption based on this that there is a reference to anyone under the age of 18, but this hasn't not been clarified specifically in the DSA. I don't know if you wanted me to also touch on the age verification aspect, because the DSA actually has a contradiction, which is why I always use the caveat that the DSA is not actually finished just yet. Because in the two provisions that I discussed with you, so of course you have the provision specifically for the online protection of minors, which includes that ban on targeted advertising and the prohibition on the collection of personal additional data in order to conduct age verification. I think this was a big point during the conversations in the DSA, taking into kind of the free expression, free access to information, the privacy concerns that there would be when it came to age verification. So the legislators agreed that they would put this prohibition in. In the same breath, in the articles that I mentioned previously around the systemic risks and mitigation of those risks, it actually includes language that says that targeted measures for the online protection of minors can include age verification. So this is, the DSA is not clear just as of yet. We are still clarifying this at this moment in time. So there's a lot of discussion kind of ongoing, and this will be formulated in what we call a delegated acts. I'm really sorry for all the EU speak that I'm using today, but delegated acts are essentially additional acts that the European Commission kind of write out and kind of have to agree in terms of how are they actually going to implement the provisions that they've written out. But so they're kind of official guidelines, they're informal guidelines, and so this will be mapped out in those delegated acts, of which the DSA has a lot that they will have to be able to formulate, not just on this, but on all other aspects of it too.
Thank you. That's fantastic. And I think we'll dive right into age assurance and age verification. Just wanted to cue the definition of minor to Charlotte and how the EUK thinks about it.
Yeah, I think the age appropriate design code applies to under 18s. So any service that is designed for children under the age of 18. The online safety bill kind of clarifies two areas of risk assessment. One is a risk assessment for adults, and then there is a child-centric specific risk assessment that is highlighted currently in the bill, which also applies to under 18s. And I think it is different to what has happened before, and a bit similar to what Landon was describing. There was always the kind of 13 cutoff in terms of consent. So anyone under the age of 13, they weren't allowed to consent, because a lot of the time we were deferring to COPPA in relation to privacy. And then between the age of 13 to 16, there was a different set of measures. And then above kind of 16 to 18, there was a different set of measures again. But 18 is kind of the definition as it stands at the moment.
One thing I'll just jump off of that and say too is one of the concepts that's in the Age Appropriate Design Code Act here, and I believe it's pulled from the UK's Age Appropriate Design Code Act as well, is that it does kind of give a directive for tailoring the level of privacy and security within the features to the age of the individual, which is to say something for 6-year-olds is going to be significantly different than something for 17-year-olds. I think that is also a concept that hasn't previously existed in California law. And so there's a bit of discussion within the legislature about what that means and where kind of the guidance on how to implement that is going to come from. But in terms of what is a minor, I think it is, again, sort of a paradigm shift in introducing, a broader spectrum of ages rather than considering minors to be kind of a single entity.
Yeah, absolutely. And in fact, in the age appropriate design code, there are examples of the kinds of things you might want to provide to the different age groups, in terms of whether it's kind of primary age children, so under 11 or 11 to 14. So there are some really specific examples in terms of the measures and support and education that you might want to provide to children.
Fantastic, thank you. And I think we have a couple questions that expand on this into age verification, including from Nicole Lopez as well as Julie Dawson. And how and Asha already mentioned the contradiction here that the DSA has, but also the theoretical of how can you minimize data collection and data processing at the same time as needing and being required to know how old each user is, like how that balance strikes. And I know each jurisdiction is dealing with it slightly differently. So yeah, I would love to hear your thoughts if you have recommendations for how to best do that, or partnerships or best practices. Obviously this is still emerging and there's lots of work being done on this, so I understand not many things are final on this, but in order for companies to comply, it's very important.
Yeah, I mean, I can kick off. I think this is an open question in California. Currently, as the bill is moving through the legislative process, it has support from a number of groups and it has opposition from some industry groups. It also has opposition, unless amended, from some privacy groups, in large part because of concerns around information collection for age verification. In part to address that, amendments have been added to the bill to explicitly require that any information collected for age verification can't be used for any other purpose. Obviously, that only goes as far as compliance and enforcement. I think that technologically speaking, there are ways to silo off that information and not use it for other purposes. But from an administrative standpoint, it's very difficult to figure out how to make that the case. And this is actually in the Age Appropriate Design Code Act in California. There's a number of kind of regulations and concepts that need to be further fleshed out by executive branch agencies. So within the Privacy Protection Agency, it establishes a task force to look into this. One of those issues is how to deal with age verification in a manner that's still protective of personal privacy.
Just in terms of the age appropriate design code, and I think this is an issue that does kind of rumble around, and lots of people are trying slightly different tactics. Age capture, some people are using hard identifiers, some people are using kind of third-party identifiers to verify age with the assurance that there is no exchange of kind of data between the company and the third party that is checking age. Sometimes it's biometric systems, face recognition. Sometimes it's using, well, the hard identifiers like things like passport, driving license, even, there was one scenario where we're using bus passes for children who get free transport between the age of 16 to 18. So there's a whole kind of range of age assurance vehicles. I think other people are using kind of AI and machine learning to detect underage accounts, and I know that TikTok have removed a whole load of underage accounts by kind of using AI and machine learning to identify those accounts. So there are a variety of different ways of doing that, and I think the important thing is is that all providers are able to demonstrate the rationale as to why they have taken a particular approach to age assurance, and to then obviously make sure that whatever content the child is seeing in relation to that age, it's appropriate for that age. I think at the moment, everybody is trying to work out the best way of serving their users on their platforms, and being able to protect children, and making sure that they don't come across inappropriate content, and also that it's not an overbearing process for any user to be able to identify their age. The area where it has come in, and it's going to be much more enforced in the online safety bill, is in the area of pornography. So you will have to prove that you are over 18 to actually access any kind of commercial pornography site in the UK once the online safety bill comes into play.
So I can very quickly just add on to this finally. You know, I think in terms of what's going to happen with the DSA, there's a lot of things to balance there, not only in terms of the existing EU law that needs to be in reference to, but there's the harmonization principle. So all EU legislation needs to be able to work inside with one another. And so then you, of course, you have the GDPR data minimization principle, which needs to be respected. And as you may have seen over the last year, due to the frustrations, I think that came with the enforcement of GDPR, there's been a lot push, a bigger, stronger push for more robust enforcement of GDPR. You may have seen some of the opinions and reflections by the European Data Protection Supervisor and some of the data protection agencies on how they wanted to reinforce this. So this is why the DSA has also taken on a role to kind of enforce that too. So it seems to me that's why the legislators were so explicit in having that prohibition on additional data collection in that provision around targeted advertising towards children. But I think obviously where it then mentions age verification, is within a kind of recommendation of what could be used moving forward. But of course, there are obvious privacy and free expression concerns when it comes to in a horizontal framework like the DSA, because it is a regulation, which means it does get parachuted out into all 27 EU member states. Having that in a horizontal framework, I think, raised quite a few very legitimate questions when it comes to privacy and free expression concerns. And so the other question that there was is that within these systemic risk measures, none of the mitigation steps that they take can pose any risk to other rights under the Charter of Fundamental Rights. So it is going to be about this balancing of how those measures are adopted in providing, you know, rightly so in terms of the protection that's needed, but also making sure that it doesn't impose risks in other areas. So this is why the DSA has adopted at this moment in time to formulate that and at least have it outlined in delegated acts, because that means there's another round of kind of consultation, another round of thinking this through, thinking about it practically. The law is there. How do we actually concretely do this is where they're going to be going with this. So we're hoping to engage quite a lot on that in order to help them bring it to life.
Excellent. Thank you. This is a fantastic expansion on this discussion, as age assurance and age verification will become increasingly more necessary and required by law, and there are different statutes. I know we alluded to some of this, but I did want to get into some of the questions that focused on ed tech. There's some very specific and nuanced questions here. So I think maybe Charlotte can probably speak to the first two, maybe from Nicole Lopez and Julie Dawson, asking, Charlotte had previously mentioned that some of the age appropriate design code doesn't apply to every service. So who were sort of the players figuring out the scope of the age appropriate design code and how it impacts ed tech companies, as well as is maybe self-assertion or tick boxes, is that used only for the lowest risk in ed tech platforms moving forward? And then for Landon in California, for student data privacy laws, how are they current laws compatible with the age appropriate California's AADCA? So maybe we'll start with Charlotte.
Yeah, there has been some research done by Five Rights and Sonia Livingston, who are prolific, both prolific people in the online safety area. I can send you the link to the research that they've done, but they are lobbying quite hard for the scope of the age-appropriate design code to include EdTech. And for those of us that work in the UK and indeed, internationally in Europe and the US, we will know that there is a lot of data that sits across all of these systems, not just kind of learning platforms, but also the MIS data and all of the sensitive data that's contained within a lot of the online systems around safeguarding children. So the case management systems that exist in schools. So there is a little bit of a driver towards making sure that they become in scope of the age-appropriate design code, because it's a multi-million-pound industry and nobody really knows how data safe they are. Whether that succeeds or not, I don't know. I suspect it might, and it might become within scope of the age-appropriate design code. Whether it becomes a tick box exercise, I think will be interesting, because obviously schools have their own compliance issues with GDPR, with all sorts of with making sure that data is safe, making sure that we are compliant. So there is a kind of level of protection and security that already exists, because schools have to be compliant with that anyway. But often they are buying commercial off-the-shelf services for students and for teachers, which again might not necessarily understand the kind of safety, security, privacy issues within those systems that they're buying. So it hasn't bottomed out yet. We don't know the answer yet. There are more assurances in place, potentially less risk. I can send Andrew the report so that he can share it with you afterwards, and you can have a look at it and a read of it.
Thank you. And that's excellent, because we had received another question asking about any resources or references to research based on this area. So thank you. We will absolutely send that out with the recording of this video later this week. Thank you.
Thank you.
And then in terms of California's existing laws with respect to EdTech and K-12 privacy, the California's probably strongest privacy law, or one of its strongest privacy laws, actually pertains to student online personal information. So the Student Online Personal Information Protection Act was passed in 2014. We refer to it as SOPIPA. It effectively does a lot of the things that the age-appropriate design code attempts to do. It prohibits profiling. It prohibits certain types of collection of personal information and uses of personal information. The issue, of course, is similar to most of the laws that are governing children's online safety, which is that this is yet another instance where there's a standard of actual knowledge or of intentionality, in which if the service is not created primarily for the purpose of serving K-12 students, and if it's not marketed for educational purposes explicitly, then it is not governed by this law. And so one of the benefits of the Age Appropriate Design Code Act in this respect is again sort of transitioning from this actual knowledge and an intentional standard of developing this for a K-12 audience as opposed to a general audience, and transferring over to a standard in which, if it's likely to be used for that purpose, then it's governed by certain protections. I think that it's a little bit less, the actual knowledge standard is a little bit less of an issue in this context with respect to kind of explicit K-12 ed tech materials, but a lot of the educational resources online can contend that they are developed for general audiences, and in doing so avoid a number of these protections. And so it will be interesting to see. I'm not sure that the Age Appropriate Design Code Act intends to deal explicitly with ed tech in any way independent of other types of information, but it will be interesting to see, now that we already have this privacy framework in place, how shifting the presumption over to users being children rather than adults will affect the application of SOPIPA.
Excellent, thank you. I also wanted to bring this back to Congress, at least for a second, for our US-based audience here. I know we're mostly focusing on international today, but after hearing all of this progress in online safety policies, it's not controversial to suggest that Congress has fallen behind both internationally and domestically. So what is your advice directly to congressional staffers who might be tuning in today? Are there one or two things that they should emulate from other successes in online safety policy, or one or two things that they should avoid and mistakes they should learn from? Would be really interested to hear your educated perspectives on this.
Can I say something, Andrew? I just wanted to say that I think the approach of kind of risk assessment is really important, and tailoring services that are appropriate to children. As I said, I've worked in this area for a long time, and it kind of feels a little bit sad that we had to get to the stage where we had to regulate, to be honest. I think it would have been inevitable that we had to get to this stage. But I think given the kind of increase in things like child sexual abuse imagery, and the IWF saying that they've had more reports in the last year about child sexual abuse imagery than they have in the last 15 years, we absolutely have to do the best we can for children in the online context and environment. We didn't build the internet for children. We know this is where they hang out, this is where they like, this is where they love. We've particularly seen that during the pandemic. So I think having this approach of risk assessment is really important. I think demonstrating that you as an organisation have thought through what the risks are and mitigated those risks without compromising the experience, because what we can't have is children going online and obviously being on sites and services that the risks have been mitigated so much that they're not interactive, and children find them incredibly boring, which I know that we're not going to get to that stage. But I do think that the kind of balance of risk, rights, responsibilities is really important, and I would really encourage people to take that approach on board. I think it's important.
So I would be happy to add to this, because I definitely wanted to plus one on the risk assessments aspect. This is something we were working on very diligently in the EU space on the Digital Services Act, to try and have human rights impact assessments very clearly within the text. We didn't get the language human rights impact assessments, but we ultimately, I at least believe, ended up with human rights impact assessments, and that's so crucial. My advice would be to also just take inspiration from the aims of some of these legislations. That the DSA itself is incredibly ambitious. And as a horizontal framework, it really has to set a good foundation for the protection of all users, to which specific actions and measures could be built on from above and beyond. I myself, I have a background, many years as an advocate looking to eradicate online gender-based violence. And so seeing in the Digital Services Act, for example, a clear understanding that this can be a specific risk, just like the protection of minors, it can be a specific risk, but we have a separate directive that looks at gender-based violence, criminalizes certain forms of online gender-based violence, that then makes the foundation that the DSA sets much more concrete. So then it needs to be a very kind of comprehensive and nuanced approach. Once you have, a very solid baseline legislation, privacy legislation, and that includes online safety, you can then start to build from there. And the other aspect I would say is, I can't reiterate this enough, I say this everywhere I go, but the need to work for civil society on this, because they will be able to answer those questions. So will technologists, so will academics be able to answer those questions that are coming up in policy discussions, because you're having to have those reflections as you try and manifest the law. So to have them really in concrete included, so that they can be able to help shape those legislations with you. But just again, very succinctly, to kind of have that baseline protection in legislation, build upon from there, and work closely with the experts and civil society to keep improving.
I'm going to take kind of a different tack on this. I think there's two kind of more process or procedurally based issues that I think folks in Washington would benefit from considering. I think the first is that we, as I think is apparent from this conversation, in the United States are very behind on just developing the basic infrastructure around data privacy and online safety. And I think it's worth noting that while this is where I should again reiterate my disclaimer, I'm speaking for myself and not for the committee. I think it's worth noting that by expanding broader privacy protections for everyone and not just children, while it may be more politically expedient to address specifically children, you create frameworks that make it much easier to put into place legal structures that then can protect children more efficiently. I think some of the issues we're dealing with in California with respect to the Age Appropriate Design Code Act and other things is that we just don't have the infrastructure. We don't have the institutions to rely on for enforcing these sorts of things or for providing the governance and guidance necessary to actually effectively implement them. So I think that's something worth contemplating, is really, rather than kind of trying to address children first, even though children might be the most important component of this in many ways, we need to build a broader privacy infrastructure in order to effectively deal with issues concerning children online. The other thing I will say, because I know this is a big discussion on the Hill currently, is I would highly recommend against preempting stronger state privacy and online security laws. I think it is, while it is much more, while compliance is much easier with a nationwide privacy law, and indeed a nationwide baseline set of protections is essential, it's clear that Congress lacks the agility in many ways to address the changing landscape of digital technology with the efficiency that's necessary to keep up. Allowing states, which in many cases have a much quicker and more agile system for passing legislation, to kind of be on the forefront of expanding these protections, I think is really critical. So in California, we deal in large part with many preemption issues around Section 230 and the like. I think it's important to make sure that while a national privacy framework is essential, that it doesn't preclude states from providing additional protections and, when necessary, responding to new emerging issues online.
Thank you. Yeah, thank you, each of you. This was super helpful advice. We work a decent amount on the Hill and with staffers, and these host these partially directly for them. So it's great to give advice from people who have actually been working on things and passing things, especially when it comes to preemption and starting from a privacy or risk-based baseline here. I want to be mindful of the time since we only have a couple minutes left. So I want to turn to the future. How do we future-proof some parts of online safety policy instead of maybe feeling like we're always playing catch-up? Can we craft policies for today's platforms while also thinking ahead to the metaverse or other technological advances?
I think it's really important that we are agile and forever learning in this space. I think it's going to be absolutely crucial. And again, one of the debates that's been raging in the UK is this issue around whether we should be moderating, managing content, or whether we should be building the systems to enable people to better manage whatever the content on the platform looks like. And I think in order to future-proof ourselves and to further protect children and to create safe spaces where they can still have really positive interactive experiences, we need to think much more about the systems and processes that sit behind all of these online services that we provide to children. So it's much more around making sure that all that effective governance is in place and the system is in place, rather than actually saying, oh, that this content fits into a box and this one fits into another box. I think we need to think about it much more broadly, because if we don't, the bill that we're currently going for at the moment is not going to be fit for purpose in 10, 15 years' time. We're going to have to start again, and no one will want to do that. So we need to be really flexible in the way we approach this.
And I'll just jump off of that. I mean, I think I started to get a little bit into making sure we have that level of agility and making sure that we have the infrastructure necessary to build off of a basic set of privacy laws. I think it's also important that we approach this from the angle of shifting incentive structures. I think regardless of what the specific technology is, a number of the ills that have emerged from social media and from some of this online content are a consequence of the way that we've structured incentives. I'm not sure what the answer is there, but I do think that as Charlotte alluded to, this is not an issue of saying this content is bad, we need to get rid of it. It's an issue of making sure that these companies are incentivized to be good actors and act in the public benefit.
And I can just add to that very, very quickly to kind of +1 on those points, thinking about due diligence when it comes to incentivization, looking at the UN guiding principles, for example, on businesses and human rights to kind of feed into the legislations that we're building. But coming back to your question on the future-proof aspect of it, I mean, the DSA is also an example where they've built in a regular process of review and adaptation into the legislation itself. It requires it and understands that it needs it. The AI Act, which is something else the EU is working on that we have not had time to think about today, has annexes specifically so that they can deal with these things in these annexes and think about it over a longer period of time. And a message I would leave with today is, the need for that kind of stronger global alignment between the different regulatory pieces that are being developed. One, so you don't have competing legal regimes as just a basis to make sure things work coherently. And two, so that we're working towards this global goal of having a digital ecosystem that is safe, that is rights respecting, that is accessible, and that is meaningful for all those who use it. So this for me is where I would like to see us going.
Excellent, excellent. That cues us up perfectly. I mean, we're getting so many questions that I wish we had more time to get to, especially as Asha mentioned at the beginning, we could talk for 2 or more hours just on specific parts of this. We've gotten questions about congressional legislation. There are some FOSI briefs that we've written in the past 2 months, one on California's Age Appropriate Design Code Act and one on the Kids Online Safety Act, both before Congress and then in California state legislature. So you can find that at fosi.org. And taking Asha's last point to the final question, where each person just want to give you a pretty short answer of if there's one thing that you want the audience to take away from your appearance today and what we've talked about today already, one final takeaway from this briefing.
I think the issue that Asha's just raised around the kind of interdependencies globally around, because what concerns me, and I'm not saying one thing, sorry, is that we will, if we don't get the legislation that is interdependent, that will have vanilla services in one area of the world and not in another. So I think that will drive people to kind of, go on the dark web and access services in a kind of different kind of way. So I think we do need to make sure that there is that kind of global interdependencies between the legislative and the regulatory frameworks. It's really important.
And I'm going to cheat and say 2 things, but one of them I think gets back to this concept that, children's online issues are people's online issues, and people's online issues are children's online issues, and online issues are similar to offline issues. And I think we tend to think of online issues, and particularly children's online issues, as very siloed concepts that we need to deal with independently. I think that there is a bigger picture to it that needs to be contemplated when trying to deal with this. The other thing I will say is that we are fortunate here to have folks from various countries who are at the forefront of these kinds of issues. There is a lot of the world that is not represented here and that is not being contemplated. And I think to some extent, as the folks leading in this area, I think there's a bit of an imperative to make sure that we're incentivizing good behavior at the global scale.
And I will just take 10 seconds to, again, +1 on this. I would reiterate the point that right now is an opportunity to our congressional colleagues who may be here and to learn from our experiences in building the online safety bill and the DSA and all the different pieces that we've been talking about, to build from the very positives of those, to have something that can be fantastic. I mean, the TTC is happening today. There are a lot of opportunities to keep building. None of these legislations are finished. They're not alive as of yet, but they are moving very, very quickly. And so just making sure that we are all coherent around this. And I would like to close on a point just made there by Landon about this kind of online and offline issues, right? Because what we are talking about are societal and systemic forms of risk, of lack of safety, of discrimination that continue to manifest in our online spaces. And so I would highly recommend a kind of very intersectional methodology adopted when it comes to the formulation of any initiative moving forward, and the increasing of collaboration amongst organizations who may be working on this, whether it's child rights organizations, digital rights organizations, traditional equality bodies. There are a lot of people who could be invested in ensuring that we're all working towards the same goal.
Fantastic. Well, I am feeling so optimistic after this conversation today. Thank you all to our fantastic speakers. Thank you also to our engaged audience and for all the great questions that you submitted. We are also thrilled, as Stephen put in the chat, we are thrilled to announce that our next event will be in person in London for our 2022 European Forum on June 23rd. So if you're in London or can get there in the next month, we'd love to see you in person as we take a transatlantic view of online safety. Thank you again to everyone, especially our speakers, and have a great rest of your day.
Thank you.
Thank you.